talking about the next section of the rules, specifically competence, legal malpractice, and other civil liability. So the first thing I want to point out is that this subsection of the rules makes up 6 to 12% of your total MPRE exam. It's one of my favorite sections of the rules because I feel like if you really memorize this about a full page of rules here, you can maximize your chances of success on the exam. And that's because there's not many rules here, and yet it can make up to 12% of your total exam. So I guess that's kind of a long way of encouraging you to really own this section of the rules because, again, I think it spans such a short amount of information. If you understand it and know it, you're putting yourself in great shape for your exam. So the first rule that I want to point out is the first one, which is competence that's necessary to undertake representation of a client. So first, let's look at the rule and then we'll talk through it. So it tells us that a lawyer shall provide competent representation to a client, and that competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for representation. So just to stop there, this is essentially the basis in which we should be providing all of our representation to our clients. So what happens in other circumstances, however? What if there's an emergency that comes about? What are your obligations under these rules? Well, the language of the rule tells us that in an emergency situation, a lawyer may give advice or assistance in a matter in which the lawyer does not have the skill ordinarily required, where referral or a consultation to or associating with another lawyer would be impractical. Even so, assistance should be limited to what is reasonably necessary in the circumstances. So let's just talk about what this means, and then I'll give you a quick example. What this means is these rules recognize that sometimes we as lawyers are put in a position where we might not have everything it takes to ordinarily represent a client, but the circumstances don't allow us to reach out to someone and refer the case out or to associate with someone to make sure that we're providing that competence when it comes to the representation of the client. So for example, for instance, let's say there's a lawyer and she gets a call that her brother got into a terrible car accident and he's in the ICU of the local hospital. So she stops what she's doing and she rushes over to the hospital. And it turns out her brother is in terrible shape and he knows it. And he requests that she draft him a will because he doesn't have one and he truly believes that he's dying. So she steps out of the ICU unit and she calls a friend who happens to be a probate attorney because she herself, while she's a lawyer, she's a real estate lawyer. So she hasn't written a will or she really doesn't know the specifics of it because that's not her area of expertise. So she steps out, tries to reach her friend who is a lawyer who can handle this type of matter, but she can't reach her friend. And she knows that time is of the essence because her brother is sitting in the hospital actively dying. So she decides to go back to him and to respect his wishes and to draft him a will pursuant to his wishes. So she does just that. He ends up ultimately dying, and the will that she drafted on the spot in the hospital ends up getting probated. If there's any sort of question about if she will be subject to discipline for her actions, the answer is no, because that's precisely the type of emergency circumstances these rules are contemplating when it talks about allowing a lawyer to do something that they might not ordinarily have the competence to do, but the circumstances require action. The one thing I do want to point out, though, the rules make it clear that even in an emergency circumstance where you might be permitted to act, you should still make sure that whatever you're doing is as limited as possible. So do just enough to handle the circumstances or the situation and then pass it off to someone who is more competent to take over for you. So again, you're trying to keep your actions as limited as possible, even in an emergency set of circumstances. So when it comes to novel fields of law, lawyers can acquire competence through studying or by associating with another lawyer who maybe has expertise in that field. When it comes to consulting another lawyer, and here are the rules talking about circumstances where you as a lawyer are reaching outside of your firm. So you're not consulting with another lawyer in your firm, but again, you're reaching out to someone outside of your firm walls. And you can do this to help provide legal services to a client, but before you do so, the rule makes it abundantly clear that you should obtain informed consent from your client. And when we say informed consent as it relates to this rule, this type of informed consent does not have to be in writing. Is it a good idea to get it in writing? Sure. Does the rule require it be in writing? No. The next rule that I want to talk about is civil liability to your client, including malpractice. So before we dive into what this specifically means, you really have to get comfortable with the difference between discipline and civil liability. And that's what this outline is attempting to communicate to you. So a civil case is brought in court, in a civil court more specifically, rather than before a disciplinary board. And a civil action is going to be brought against you by a plaintiff, usually a former client, rather than, say, the state bar, who would be bringing a disciplinary action against you. And the whole purpose behind a civil action, usually being brought by a plaintiff, which is usually a former client against you, is to benefit themselves. Usually they want money, and if they win their lawsuit against you, they're going to get money. Where if you get disciplined, the client's not getting anything of benefit to them. They're not going to get money, for instance, if you're successfully disciplined. So you kind of have to keep these two things that can happen to you as a lawyer separate. So let's recap that. If you get sued civilly, you're being sued in court by a plaintiff, and what they're seeking is usually money damages against you. So if they win, the benefit of that lawsuit will flow to them. If you're getting disciplined, you're usually being brought in front of a disciplinary board by the state bar. And if they're successful in showing that you have violated your ethical obligations, it usually results, in anything from a warning to a fine to a suspension of your license to disbarment. So again, there's not a benefit that will flow directly to, say, a client or a former client. So keep that in mind and read your fact patterns and the call of the question very carefully to discern the difference about what they're asking. Are they asking, is the lawyer subject to civil liability or subject to discipline? Because now, as you know, there are differences. The other thing I want to point out before we talk about malpractice liabilities and other types of liabilities you might have to a client, I want you to keep in mind that disciplinary actions and civil actions are separate and distinct. So what this means is that you might violate a rule and be subject to, discipline. They might fine you. They might suspend your license. And that does not automatically mean that your client would be successful in suing you civilly. So just because you're successfully disciplined does not mean that it's a slam dunk civil case against you. So again, they are separate and distinct. Now, does it maybe help your client if they can show that you've been successfully disciplined? Sure, it might bolster their case. But again, it doesn't mean they automatically win their civil case against you. So I want to give you a quick example of what I mean. Let's say there's a lawyer who deals in real estate transactions. And he has a client who is very interested in purchasing a piece of property that's lakefront. So he gives a $50,000 deposit to his attorney, with instructions that says to make an offer on that piece of property and to give that $50,000 as a down payment. So the lawyer takes the $50,000 and deposits it into his firm's operating account. And to be clear, an operating account is usually the bank account where lawyers' salaries get paid, where they pay the secretaries and paralegals' salaries, where they pay bills, and the like. So the lawyer deposits the money into this account, and he goes about business as usual. And when he goes to make that offer on the property and he goes to make that earnest money deposit, he checks the checking account balance and realizes that there's not enough money in there to make this $50,000 down payment because one of his partners has withdrawn a lot of money for other reasons and the balance is under $50,000. So as a result, this lawyer can't follow through on his client's instructions and his client misses out on this real estate transaction. So when something like this happens, it's more likely than not the client would be successful in suing the lawyer civilly, alleging malpractice. But it's also true that the lawyer's actions here amounted to an ethical violation because lawyers are supposed to keep client property and money separate from their own. So what this lawyer should have done is should have taken that $50,000 from the client and deposited into a client trust account, not into the firm's operating account. So this one action by the lawyer is going to subject him to civil liability. His client can sue him in court, and disciplinary action in front of the state bar. So again, maybe he'll be successfully disciplined, but maybe his client won't win the civil action. Who knows? The key takeaway is they are separate and distinct actions. So let's talk about a malpractice action that a client would bring against a lawyer or a former lawyer. So this is just one way a client can go after an attorney. And this is alleging negligence. So if your client or a client is suing a lawyer for malpractice, they will have to prove duty, breach, both types of causation, and harm to be successful. So to be clear, when we say duty, this means they would have to prove that the lawyer owed a duty of care to the client. More specifically, to act as a reasonably competent and diligent attorney would owe or act in similar circumstances. When it comes to breach, it's this idea that the client has proven a duty was owed to them and the lawyer didn't follow through on that duty. Now, be careful though. Attorneys are not liable for what we call errors in judgment. As long as the attorney's actions were reasonable, then there is not a breach. So make sure you read your fact patterns carefully. And when it comes to causation, this might be the hardest part for a client to prove when it comes to this type of action against a lawyer. So remember, there's two types of causation, actual and proximate, and a client would have to prove both to be successful here. Actual causation is a but-for cause. Proximate causation is discussing foreseeability. And I think more specifically, the but-for or actual cause is usually the hardest for a client to prove because usually they would have to prove that, but for the lawyer's actions, the outcome of their legal matter would have been different. So it's kind of a high bar for a client to prove. And then lastly, plaintiff must prove they've been harmed or that they have damages. Now, there are some other actions that clients can bring against lawyers. For instance, intentional torts, things like fraud, abusive process, malicious prosecution. For these types of actions, plaintiffs must prove intent. They could bring a breach of contract action against their lawyer or breach of a fiduciary duty, like a breach of the duty of confidentiality, for instance. The other thing I want to point out is that there is a limited instance in which a lawyer has civil or owes civil liability to a non-client. So usually we think of ourselves as owing duties to our clients, the people who hire us to do a job. But there is a limited set of circumstances where we owe duties to someone that has not specifically hired you. And this is the instance of a third-party beneficiary situation. So if an attorney negligently fails to properly draft a will or maybe a trust, and they fail to make someone a specified beneficiary, that beneficiary could sue the attorney in question, even though they weren't technically the client of the attorneys. And then lastly, I want to point out that under these ABA model rules, we are not required as lawyers to have malpractice insurance. So again, maybe your state or local jurisdiction rules require it, but here for MPRE purposes, you're concerned with the ABA model rules and they do not require insurance. So that wraps up this section of the rules.